Department 1, the Honorable Judge Virginia Phillips presiding. Please be seated. The court is now in session.
I want to begin, as I'll probably end, by saying congratulations to both of the teams. I know you've already worked very hard to get to this point, and you really deserve sincere congratulations. So we will begin. I understand there is a motion from the defense.
The defense respectfully requests that you grant the motion to suppress the statement made by Cameron Aubrey. As it is fruit of the poisonous tree, there was no attenuation. The statement was made during a custodial interrogation without Miranda warnings having been given. On March 7th, while eating at Cameron Aubrey's restaurant, Officer West approached Cameron Aubrey and told him, "I hate how you treat your employees." An argument ensued, which ended when Officer West demanded Cameron Aubrey's ID and told him to wait here. Officer West arrested Cameron Aubrey, put him in the back of the patrol vehicle, and started driving back to the police station. On the way back to the police station, Officer West learned that the warrant he received for Cameron Aubrey was for actually a different Cameron Aubrey. Rather than releasing Mr. Aubrey, Officer West turned the vehicle around. Then Officer West turned to Cameron Aubrey without reading him his Miranda warnings and made the statement, "It's your lucky day, but I still think you're abusive to your cook."
Well, why were Miranda warnings needed at that point?
Miranda warnings were needed at this point because Cameron Aubrey was still in custody. Now, if we look to the case of Thompson v. Keohane.
But let me interrupt you again. Even if I accept your premise that he was in custody, what interrogation took place? I mean, all you've said is that he made a statement to him, "It's your lucky day." He wasn't asking him a question. He wasn't interrogating, so why was it necessary to give a Miranda warning?
Well, Your Honor, if we look to the case of Rhode Island v. Ennis. Now, in this case, we had two police officers in a police car. They were addressing each other in this case. And
saying, wouldn't it be, this is the case about the weapon, right? Wouldn't it be awful if a child was hurt?
That is correct. The police officers make a statement about that to each other. Now, the defendant hears this statement, but in this case, the statement was admissible because the court defined interrogation as any actions or words on the part of the police that the police should reasonably know are likely to elicit an incriminating response from the defendant.
All right, but how is the statement, "Today's your lucky day," how would a reasonable police officer think that that was going to lead a suspect or a person in custody to make an incriminating statement?
Of course, Your Honor, because Officer West had already engaged in a heated argument with Cameron Aubrey about his treatment of his employees. In fact, that's how this entire incident started. Officer West made a statement regarding Cameron Aubrey's treatment of his employees. Cameron Aubrey responded the first time, and Officer West reaches the end of this investigation still with nothing. So Officer West again brings up a statement that he'd already received a reply to. Again, he mentions Cameron Aubrey's treatment of his employees, and once again, Cameron Aubrey gives a response. Officer West baited Cameron Aubrey into making that response because he knew he could get one just like Officer West did before.
All right, go ahead.
Officer West, after making the statement to Cameron Aubrey, replied with the statement at issue. "I don't know who you think you are, but you need to understand something. Everything under that roof is mine." In the case of Terry v. Ohio, the United States Supreme Court stated that an officer is permitted to make a limited stop and frisk when that officer can point to specific and articulable facts which justify the brief intrusion on the defendant's constitutional rights. In our case, Officer West had no facts on which to base his seizure of Cameron Aubrey, and the demand for Cameron Aubrey's ID was punitive. Officer West's actions were illegal and in bad faith. In the case of Taylor v. Alabama, the United States Supreme Court stated that a statement obtained subsequent to an unlawful arrest will be excluded as fruit of the poisonous tree, unless there are any intervening...
Let me interrupt you. When you say he had no facts on which to base his arrest...
That is correct.
What about that note?
The note that's disputed in trial had not been received at this point. This was on March 7th.
Oh, I apologize. All right, so the facts were only, the facts that he would have had at that point were only what he had observed.
But Officer West had no specific or articulable facts at that time to which Officer West can point to that would justify his intrusion on Cameron Aubrey's constitutional rights.
So what he had observed regarding, it's Lynn Stark.
Lynn Stark.
What he had observed in terms of Ms. Stark's conduct, how hard she was working when she was scolded by your client, et cetera, you don't think those are sufficient?
Absolutely not, Your Honor. Clearly, Officer West did not meet reasonable suspicion, or Officer West would have arrested Cameron Aubrey for human trafficking right then and there. But Officer West didn't, because Officer West had no specific or articulable facts on which to base his seizure. Further, the court held that an inarticulate hunch alone is not enough for an officer to intrude on the defendant's constitutional rights.
All right, go ahead.
So again, in the case of Taylor v. Alabama, any statement subsequent to an unlawful arrest will be excluded unless there are any intervening circumstances
2 minutes.
that break the causal connection. In the case of Utah v. Strife, the United States Supreme Court set out a three-part test to determine attenuation. First is the amount of time between the arrest and the evidence obtained. The shorter amount of time, the stronger the link between them. Second is the presence of intervening circumstances. And third is the purpose and flagrancy of the police misconduct. In our case, we had a very short amount of time, lasting only 10 minutes, suggesting a strong causal connection. There were no intervening circumstances, as Officer West's continued misconduct occurred throughout the entire 10-minute incident. Officer West's sole purpose was to punish and harass Cameron Aubrey. Further, the statement must be excluded as it resulted from a custodial interrogation without Miranda warnings having been given.
Well, again, that comes back to my question of whether the comment, "it's your lucky day," amounts to an interrogation, right?
That's correct. And again, in the case of Rhode Island v. Innis, an interrogation is defined by the Supreme Court as any actions or words on the part of the police that they should know would be reasonably likely to elicit an incriminating response from the defendant. Officer West had already brought up Cameron Aubrey's treatment of the employees. So when Officer West again makes a very similar statement, he gets a response. Again, Officer West knew it was going to work the first time, and Officer West used it again the second time, knowing that an incriminating response was going to be made by Cameron Aubrey.
All right.
In the case of Thompson v. Keohane, the United States Supreme Court defined a custody as the circumstances surrounding the interrogation, and given those circumstances, would a reasonable person have felt at liberty to terminate that interrogation and leave? Cameron Aubrey was being kept in the backseat of a locked patrol vehicle, where Cameron Aubrey physically could not leave that vehicle. Cameron Aubrey was never told he was no longer under arrest by Officer West. There was no mention as to his current status. Officer West didn't pull the vehicle over.
But he turned it around, correct?
But a reasonable person, Officer West did turn the vehicle around.
So is it your position that he should have, at that point, just stopped the car and let your client out in the middle of where? A highway?
Well, Your Honor, clearly I wouldn't be advocating to just dump my client in the middle of moving traffic. But at least if Officer West would have let Cameron Aubrey out, it would have been unequivocal to all parties involved that Cameron Aubrey was no longer under arrest. But the problem is that Officer West did nothing. Officer West didn't mention Cameron Aubrey was no longer under arrest. Officer West didn't offer Cameron Aubrey where he wanted to go. Didn't say anything at all to Cameron Aubrey. So a reasonable person, given this set of circumstances, after being harassed by the police officer, they're in the back of a locked patrol vehicle, essentially a jail cell on wheels, and the officer says nothing to them. A reasonable person in this situation would not feel at liberty to terminate that interrogation and just leave.
All right. You may continue.
Finally, the interrogation by Officer West was unlawful. If we look at, just for emphasis, to go back to the case of Rhode Island v. Innis, an interrogation or any words or actions on a part of the police that would be reasonably likely to elicit an incriminating response. Officer West knew that he could get a response from Cameron Aubrey. Officer West did it before, when mentioning the treatment of Cameron Aubrey's employees, and Officer West does it again at the end of this interrogation. Officer West's
30
flagrant
seconds.
misconduct has tainted this case, and if we look to Brown v. Illinois, Cameron Aubrey's subsequent actions were not of a sufficient act of free will to purge the primary taint of Officer West's continued misconduct. And it is for these reasons the defense respectfully requests that you grant the motion to suppress the statement. Thank you.
Thank you. All right, and for the prosecution, Ms. Oyama?
Yes, Your Honor. May I proceed?
You may.
Officer Hayden West obtained a legal, voluntary statement. The admissions made by the defendant are relevant to the issue of guilt and should be admitted at trial. Now, the defense's argument begins with the initial interaction outside the defendant's restaurant. The people concede that this was a detention. We agree that Officer West did not have reasonable suspicion as required by Terry v. Ohio. However, the 2016 Supreme Court case of Utah v. Strife is squarely on point. In Strife, the police made an unlawful detention, and they then used this detention to question the suspect. Those improper acts allowed the officer to find a warrant, and he subsequently made an arrest. Yet the Supreme Court held that evidence seized incident to that arrest was lawfully obtained. And why? Because the link between the initial stop and the evidence seized had been broken by discovery of a warrant. This is the High Court's attenuation doctrine. In our case, discovery of a valid active arrest warrant, whether or
For
not...
a different person.
Yes, Your Honor, but whether or not it was for this Cameron Aubrey does not matter, because Officer West reasonably relied on the warrant. But let's move back to the case of Utah v. Strife. That's true. The warrant was for the actual person arrested, but the court did not base its holding around Edward Strife's status as a person with an arrest warrant. Instead, the court focused on the officer's discovery of a valid active arrest warrant. Discovery of a warrant was the intervening circumstance identified in Strife. The High Court recognized that once the officer discovered a warrant, he had a legal obligation to make an arrest. As the court knows, an arrest warrant is a court order directing police officers to make an arrest if they come across a suspect named. Officer West also discovered a warrant, and that's an intervening circumstance under Strife. Therefore, whether or not it was this Cameron Aubrey does not matter, because the question we must ask is whether or not Officer West reasonably relied on the warrant, and she did. To begin with, the name Cameron Aubrey is not common. It is therefore significant that the names were identical, and the spelling on the warrant was also unique. Aubrey is usually spelled A-U-B-R-E-Y, not with an A-W. Yet that unique spelling matched perfectly as well. Height was also a perfect match, and as the court knows, height is something that does not change. And while there was a slight weight difference of 20 pounds, it did not automatically signal to the officer that she had the wrong suspect, because as we know, weight is something that can fluctuate greatly over time. So the question is whether or not Officer West reasonably relied, which she absolutely did.
All right, go ahead.
Now, turning to the case of Herring versus United States. The police made an arrest based on an inactive warrant. The unlawful arrest could have been avoided had the officer simply inquired further from dispatch. Nonetheless, the High Court held that evidence seized incident to that arrest was admissible. And that is because the officer acted in good faith. In other words,
Isn't there a bit of a question here about good faith, given what had already, the exchanges that had already taken place between the defendant and the officer?
No, Your Honor, because while we concede that the initial detention was a mistake, Officer West then discovered a valid active warrant, and all of her conduct afterwards was lawful and appropriate after finding this warrant, and her actions demonstrate this during the police arrest. The people acknowledge that. On the way to the police station, Ms. Aubrey was under arrest, but after the dispatch call, the officer immediately listened to the dispatch call. She pulled over her car and asked the defendant to extend her left forearm. When the dispatcher said, "Warrant for someone with tattoo on left forearm, does your suspect have tattoo?" Cameron Aubrey knew that the officer heard this. So then, the officer realizes that she has the wrong defendant and immediately makes a U-turn to correct her error, and then says to the defendant, "Your lucky day, but I still think you're abusive to your cook." So these actions automatically show that the officer, it doesn't automatically, but Your Honor, it does demonstrate the officer's good faith based on her actions after the warrant.
The actions, meaning the fact that the officer made a U-turn?
Yes, Your Honor, and that the fact that she listened to the dispatcher. If the officer was
She
true...
didn't tell the defendant that he was free to go.
No, Your Honor, but she did say, "Your lucky day," which is the equivalent of letting the defendant know he is no longer under arrest. But the officer's actions were in good faith. Now, if she was truly acting in bad faith, she would have ignored the dispatch call, continued moving towards the police station, and once there, she would have made the defendant find his own ride home. That's what bad faith looks like.
All right.
Now, turning to the claim that the defendant's Miranda rights were violated. As the court knows, Miranda rights trigger only if two conditions exist: custody and interrogation by law enforcement. Here, there is neither custody nor interrogation within the meaning of the Fifth Amendment.
2 minutes.
Like I mentioned earlier, the people acknowledged that, on the ride to the police station, Miss Aubrey was under arrest. But after the U-turn, he was no longer in custody within the meaning of Miranda. By then, Cameron Aubrey knew that he had been exonerated by the officer and was being driven back to his restaurant. And he...
Well, how does he know that? All he knows is the issue about the missing tattoos, I guess we could call them, and the fact that the officers made a U-turn and said, "This is your lucky day." But he didn't say, she didn't say, you're out of custody, I've made a mistake. So your lucky day could have meant, I'm taking you to a fancier jail.
Well, Your Honor, the question is whether or not a reasonable person would feel that they're at liberty to terminate the encounter and drive off. And based on the sequence of events, Cameron Aubrey knew that he'd been let go by the officer and was no longer
But he's in
under
the
arrest.
back of a police car with the doors locked, so he can't get out unless the officer releases him.
Of course, Your Honor, and the people acknowledge that, yes, he's in the back of a police car. But in the case of Thompson versus Keohane, the court affirmed that in custody, for the meaning of Miranda, is a term of art. We must ask whether or not a reasonable person feels at liberty to terminate the interrogation and leave. In other words, formal arrest or something that feels like formal arrest. And
Well,
while
if you're in the
physical-
back of a car and the doors are locked so that you can't open them from the inside, wouldn't a reasonable person feel that he or she was in custody?
Well, Your Honor, he might be locked in the car, and yes, there may not be any door handles, but it's not a question of whether or not he can literally leave the car at that moment, but whether or not he knows he's no longer under arrest. Because yes, physical detention is a factor to consider in the totality of the circumstances, but physical detention alone does not mean Miranda custody. And if I could offer an example, a police officer pulls over a suspected DUI driver. At this point, the suspect knows that they are not at liberty to terminate the encounter and drive off. But when the officer asks, "Have you been drinking tonight?" no Miranda warnings are required. And that is because investigatory detentions do not rise to the level of Miranda custody. And returning to the court's initial question, and whether or not Cameron Aubrey subjectively knew that he was no longer in police custody, but we have evidence that he did. Remember, there are two instances when he went toe-to-toe with the officer. First, outside his restaurant, he became angry with the officer, yelled in the officer's face, but then he was arrested. And according to our record, he was completely silent on the ride to the police station. But after the U-turn and dispatch call, the defendant knew that his circumstances had changed 180 degrees. He returned to his old self, became combative when he said, "I don't know who you think you are, but you need to understand something. Everything under that roof is mine." Those are the words and actions of someone who knows they're no longer under arrest. Now, returning back to the issue of interrogation. In Rhode Island versus Innis, the High Court defined interrogation as any words or actions that the police should know are reasonably likely to elicit an incriminating response. While driving, the officer stated, "Your lucky day, but I still think you're abusive to your cook." The officer's statement was not a question. She was in no way looking for a response. But more importantly, the officer's statement, when made, did not refer to any criminal offense. Yelling at employees is disrespectful, but it is not a crime. Expressing an opinion about the defendant's management style is not likely to elicit an incriminating response. And I have two more points to make on the issue. First, based on all of the interactions previously, Officer West had no reason to believe that her comment, "I still think you're abusive to your cook," would elicit an incriminating response. Remember, she's repeating the same exact criticism as she had initially. It had not elicited an incriminating response then, so why would she now assume, just minutes later, that it would now elicit an incriminating response? And secondly, and not to sound redundant, Your Honor, but the officer was not conducting a criminal investigation. She had no evidence of a crime, and therefore no reason to believe that expressing her opinion and feelings about how the officer treats his cooks would likely to elicit an incriminating response. This is akin to telling someone that the sweater he is wearing is ugly, and the person responds by saying, "I stole it in a residential burglary." Sure, the response is incriminating, but the statement was not likely to have elicited it.
Well, except here, the statement was not simply, "This is your lucky day." The officer also said, "But I don't like how you're abusive to your cook." And the misdemeanor charge, at least, in the defendant was eventually charged with, could be termed abusive behavior, could it not?
Well, initially, Your Honor, all Officer West noticed was that Cameron Aubrey was yelling at his cook. This was not likely to be abuse, and therefore it's not evidence of a crime. And like we conceded initially, Officer West did not have reasonable suspicion to detain the ID card, but that action was attenuated by discovery of a warrant. Therefore, her comments were not referring to any criminal offense, and therefore the statement cannot be incriminating based on the officer's actions.
All right.
Your Honor, I'm about to conclude my argument, but before I do, does the court have any more questions or concerns they would like me to address?
No.
Then I'll leave you with this final thought. The defendant's constitutional rights were never violated, and his statement, "I don't know who you think you are, but you need to understand something. Everything under that roof was mine," was lawfully obtained. Justice demands that it be admitted at trial. Thank you.
Thank you. You may respond.
May I begin?
You may.
Your Honor, Cameron Aubrey's constitutional rights were absolutely violated by Officer West. As admitted by opposing counsel, Officer West made an unlawful stop of Cameron Aubrey. Officer West intruded on my client's constitutional rights because Officer West didn't like my client. Officer West's sole purpose here was to punish and harass Cameron Aubrey. Officer West didn't have reasonable suspicion. There were no specific and articulable facts. We had an unlawful stop here. And there were no intervening circumstances that broke that causal connection between the unlawful stop and the statement that was made. The warrant in this case could not have been an intervening circumstance. And when we look to Herring v. United States, the Supreme Court states that the evidence obtained in that case wasn't excluded because there was no police misconduct. And the purpose of the exclusionary rule is to deter police misconduct.
Is this really the kind of misconduct that the Supreme Court wanted to deter an officer making that kind of an ambiguous statement?
Absolutely, Your Honor. We do not want our police officers going around and accusing people of committing crimes, of detaining them.
Well, what was the crime? What was the accusation?
Officer West accused Cameron Aubrey of being abusive to his cook.
Isn't that awfully ambiguous to be an accusation of a crime?
Absolutely not, Your Honor. Telling someone it's your lucky day, but I still think you're abusive to your cook? That absolutely is eliciting a response. Accusations come with responses. This was no opinion, Your Honor. This was an accusation. Officer West intended to elicit this incriminating response. He had already got responses from Cameron Aubrey earlier, and Officer West got another one at the end, when Officer West couldn't turn up with anything else. It was a last attempt, and it worked for Officer West.
Go ahead.
The warrant could not have attenuated, as there was police misconduct that occurred before and after the warrant. The warrant itself was insulated by police misconduct. So no matter what, the statement made by Cameron Aubrey is still branching off of police misconduct, not the warrant. And if we look to the case of Brown v. Illinois, and we weigh the police misconduct here,
30 seconds.
we had not one, not two, but three separate instances of police misconduct that occurred throughout this entire 10-minute incident. Officer West was on a witch hunt for my client. The continued misconduct did not make Cameron Aubrey's statement of a sufficient act of free will to purge the primary taint of Officer West's flagrant misconduct. Thank you.
Thank you. Ms. Oyama,
Yes, Your Honor.
you may proceed.
Thank you. Now, the court was correct in questioning opposing counsel of whether or not this is the type of misconduct we are intending to deter with the exclusionary rule. Officer West is human, and she made a human mistake. But a mistake does not mean bad faith or flagrancy. They're not the same. Unlike strife, the officer did not target Cameron Aubrey. She was outside minding her own business when the defendant approached and engaged her. And while the initial detention was a mistake, all of her conduct afterwards was lawful and appropriate. And here is what I mean. She did not conduct a physical search of Cameron Aubrey or his property. And once she discovered a warrant, she had a legal obligation to make an arrest because she believed she had the Cameron Aubrey named. And therefore, the conclusion in strife is clear, and it falls in favor of exclusion. Now, we're moving on to the issue of exclusionary rule. We begin with the fundamental idea that the exclusionary rule is the most extreme remedy a trial judge can impose. It has always been the court's last resort, not its first impulse. And in strife, the court affirmed this principle in holding that an intervening circumstance, discovery of a warrant, can break the causal chain of events between the initial taint and the evidence seized. We have discovery of a warrant. A Fourth Amendment violation does not automatically trigger exclusion.
30 seconds.
Instead, we must ask if the officer was acting so extreme, so flagrant, that this court must teach the officer a lesson by deterring the evidence. Your Honor, that is not the case here, and Cameron Aubrey's statement was voluntarily made and legally obtained, and therefore the statement demands admission of trial. Thank you.
Thank you. I'm going to deny the defense motion and find that the statement can be introduced at trial. As to the two-part test that you correctly argued, Mr. DeSantis, I tend to agree with you on the first prong, that is custody, but find that no interrogation took place, and on that basis, the motion is denied. All right, go ahead, Ms. Poston, you may proceed.
Lynn Stark immigrated to the United States in 2015. Like so many before her, she was looking for a better life, searching for the American dream. But instead, she was exploited, abused, and treated like a slave by the defendant, Cameron Aubrey. Back in 2015, Mr. Aubrey opened a restaurant, The Taste of Tantera, and lured Miss Stark into working for him with promises of a better life. But instead of a better life, Miss Stark was forced to work 96-hour work weeks and was paid only around $2 an hour. She was forced to live here, in the dingy apartment just above the restaurant that had prison-like bars on all of the windows and a door that would lock automatically at its entrance.
But the door was to be kept closed at all times. I mean, open at all times.
Yes, it was, but it did lock automatically. The defendant described Miss Stark as his property, telling Officer Hayden West, "Everything under that roof is mine." All the while, Miss Stark was constantly berated and threatened with deportation by the defendant. The defendant even took and refused to return Miss Stark's passport and visa. And the people will prove that this exploitation of Lynn Stark violated Penal Code Section 236.1a, human trafficking. Almost unimaginably, on March 9th, things got even worse when Miss Stark had the audacity to ask for time off to visit her dying sister. The defendant flew into a rage and slammed the automatically locking door with Miss Stark trapped inside. With no key, Miss Stark was held captive for an entire night, only being freed the next morning just in time to get back to work. The evidence will show that when the defendant slammed that door, he violated Penal Code Section 236, false imprisonment. By the end of this trial, it will be clear that the defendant took Miss Stark's hopes and dreams and turned them into the American nightmare. It will be clear that the defendant is guilty.
Thank you. It's Ms. Adams, correct?
Correct.
You may proceed.
American writer James Truslow Adams famously observed that the American dream is a dream of a life for land that is better and richer and fuller for everyone, with opportunity for each according to ability or achievement. Cameron Aubrey was seeking that American dream when he decided to open a Tantaran restaurant with an inheritance, hard work, and loans. But his dream turned into a nightmare when his Tantaran chef could not handle the stress of working in a busy kitchen. Cameron Aubrey had always wanted to open a Tantaran restaurant. After all, he had volunteered in Tantara during his youth. And so he decided to hire an immigrant from the country that he connected with to work as his chef, Lynn Stark. Cameron Aubrey was upfront about the pay. It was to include not only a small salary at first, but a place to live and free meals. Cameron Aubrey even gave Lynn Stark money at the beginning to purchase necessities. In addition, Cameron Aubrey even let Lynn Stark make phone calls to her family in Tantara using the office phone. Devin Tyler, Cameron Aubrey's cousin, will say that Lynn Stark was working very slowly in the kitchen and that Cameron Aubrey cared for her. Frankie Lyman, a friend of Lynn Stark's and a co-worker at the Taste of Tantara, will say that Lynn Stark could not keep up with the orders in the kitchen and that Cameron Aubrey cared for her. In addition, she will say that Lynn Stark confided in her by telling her that she was worried about losing her job and that her visa was about to expire. Lynn Stark then followed with saying, "I would do anything to stay in the United States of America." Shortly thereafter, Lynn Stark accused Cameron Aubrey of human trafficking. Addison Frey, an expert in human trafficking, will testify that Lynn Stark was not a victim of human trafficking. Rather, Lynn Stark was an inexperienced employee who was not capable of handling the stress of a busy kitchen. Cameron Aubrey is not a human trafficker. Cameron Aubrey was seeking the American dream, a dream that he wanted to share with Lynn Stark. Cameron Aubrey even planned to bring Lynn Stark's family to the United States. While working for Cameron Aubrey, Lynn Stark received a salary, had her own apartment, and was able to send money to her family every single month. Lynn Stark is no slave. Lynn Stark was an inexperienced employee who would, rather than quit and risk deportation, chose to blame Cameron Aubrey. Your Honor, after hearing all of the evidence today, the defense requests that you find Cameron Aubrey not guilty. Thank you.
Thank you.
People's first witness, Your Honor.
Go ahead. Who's your first witness?
The people call Lynn Stark.
Thank you. Please come forward.
Your Honor, my name is Carly Baldwin, and I'll be doing the cross-examination of this witness.
Thank you.
Thank you.
Your Honor, may I announce the time for closing arguments?
Yes.
The prosecution has used 2 minutes and 50 seconds and has 6 minutes and 10 seconds remaining for closing arguments. And the defense had used 2 minutes and 58 seconds and has 6 minutes and 2 seconds remaining for closing arguments.
Thank you. Please raise your right hand. Do you solemnly affirm that the testimony you're about to give will truthfully and faithfully conform to the rules and facts of the mock trial competition?
I do.
Please be seated, state your name, spell your last.
Lynn Stark, S-T-A-R-K.
You may proceed.
Thank you. Good afternoon, Ms. Stark.
Good afternoon.
Do you know Cameron Aubrey?
Yes, Cameron Aubrey was my boss at Taste of Tantera.
How did you come to get a job at Taste of Tantera?
I saw an ad in a newspaper for a Tantaran cook, so I interviewed with Mr. Aubrey.
And where did you learn how to cook Tantaran food?
I was born in Tantera and grew up cooking traditional Tantaran foods with my mom.
What did Mr. Aubrey ask you when you initially interviewed for the job?
Mr. Aubrey asked me a bunch of questions about my past, family, and finances. He even asked me if anyone in Little Tantera would miss me if I was gone. I told him no.
Did Mr. Aubrey tell you anything else about the job?
Yes, Mr. Aubrey said I would have to live in the
Objection,
apartment of the...
non-responsive.
Overruled. You may continue.
Mr. Aubrey told me that I would have to live in the apartment above the restaurant. He also said that he would help bring my family over to the U.S.
Do you see Mr. Aubrey in the courtroom today?
Yes, he's to my right in a blue tie and a gray jacket.
Your Honor, may the record reflect that this witness has identified the defendant.
The identification is noted on the record.
When did you start your new job?
November 2nd, 2015.
Did the defendant take anything from you when you started working?
Yes, my visa and passport.
Did he ever give those documents back?
No, he didn't.
Could you describe your living conditions in the apartment above the restaurant?
The apartment was small and smelled like mildew. It had these 2 windows with security bars on the outside, and the door automatically locked.
Did the defendant give you a key to that door?
Not really. Mr. Aubrey only showed me where a key was.
Could you describe your working conditions once the restaurant opened?
I was working from 7:30 in the morning to 11:30 at night, usually at least 90 hours a week. Mr. Aubrey made me work on my off days too.
And how did the defendant treat you while you worked?
He would often come into the kitchen and yell at me to work faster. If I tried to take a break, Mr. Aubrey would yell at me for being lazy, even threatening to fire me. He asked if I would rather be back in Tantera with no job, so I pushed myself to work.
And how much was the defendant paying you?
I was paid $500 for the entire month of November and $400 for every month after that.
Now, while you were working for the defendant, did you receive any bad news from home?
Yes. In March, my mom told me that my sister was dying.
Objection, hearsay.
You wish to respond?
Yes, Your Honor. This is not being offered for the truth of the matter, but rather to explain this witness's subsequent actions. Specifically, that she then went to the defendant and requested time off.
You've persuaded me. The objection is overruled.
Did you tell the defendant about your sister back home?
Yes, I had asked for some time off so I could see her one last time.
And how did the defendant respond?
Mr. Aubrey told me I wasn't allowed to leave under any circumstances. I even tried asking for my visa and passport back, but he refused. I was so upset I began to walk away.
And what did the defendant do once you began to leave?
He started following me, and once I walked through the door to my apartment, I heard him slam it behind me and say, "You better get comfortable here. It's going to be a while before you go anywhere."
Directing your attention to the following morning, what did you do once you woke up?
I woke up and headed downstairs at around 6:30, but the door was still locked and I couldn't get out, so I went upstairs to look for the key, but it was gone. I started to sob and bang on the door for help.
When was the last time you had seen your key?
I saw the key the day before, on the morning of March 9th, when a pen had rolled off my dresser.
And how did you finally get out of that apartment, Miss Stark?
Mr. Aubrey finally let me out at around 7. He asked if I was missing my key and laughed at me.
What did you do after the defendant released you from that locked room?
That day I saw an officer sitting at the counter. When I brought the officer his food, I slipped him a note that said, "Please help me, I'm treated like a slave."
Objection, hearsay.
You wish to respond?
Yes, Your Honor. This is hearsay, however, it actually falls under 2 hearsay exceptions. First, it's an excited utterance. When Ms. Stark wrote the note, she had just recently been released from being imprisoned in her apartment for an entire night. Therefore, she was still under the stress of that event when the note was written. Additionally, this goes to Lynn Stark's state of mind, specifically her emotional state, that she was desperate.
And how was her emotional state relevant?
Your Honor, as one of the elements of human trafficking, the victim must be placed under duress or coercion. This note proves that Lynn Stark was placed under duress because she felt like she was being treated like a slave and was desperate and she needed help.
You may respond.
Submitted.
All right, the objection is overruled.
Do you see Exhibit B behind you, Ms. Stark?
Yes,
Is that a copy of the note you gave to Officer West?
yes it is.
Thank you. Your Honor, nothing further.
Thank you. Cross-examination.
Yes, Your Honor. May I proceed?
Go ahead, Ms. Baldwin.
You came here on a work visa, correct?
Yes, to support my family.
So you have to work to remain in the United States.
That is correct.
And you applied for a job at the Taste of Tantera.
Yes,
You had no professional cooking experience prior to this date.
I had grown up cooking, but no.
And part of your pay was housing, correct?
That is correct.
And you were given a key to this apartment.
I was shown a key.
And prior to your claims on March 9th, Cameron Aubrey never told you that you couldn't leave the restaurant.
When Miss Aubrey told me that I wasn't allowed to leave the kitchen during working hours.
Is that a yes?
Could you repeat the question, please?
Prior to your claims on March 9th, Cameron Aubrey never told you you couldn't leave the restaurant.
No, but I was always working.
And you left the restaurant every month with Frankie Lyman to wire money back to your family in Tantera.
Yes.
And you never complained to Frankie Lyman before.
No, I hadn't.
And on March 9th, you got in an argument with Cameron Aubrey because you wanted to take a vacation.
To see my dying sister, yes.
And you walked away from your employer.
Yes, I was upset she wouldn't let me see my dying sister.
And you heard a door slam.
Yes.
But you weren't concerned.
Miss Aubrey told me I wasn't allowed to leave.
You only became concerned the next morning when you couldn't find your key.
That is correct. I saw it the day before.
And that's when you decided to tell Officer West.
I couldn't take those conditions anymore.
And you'd seen Officer West several times around the restaurant before.
But I was so determined to keep my job to support my family.
You never told Officer West before this date.
No, as I said before, I wanted to keep my job.
Is that a yes?
That is correct.
And you never told Frankie Lyman.
No, Frankie Lyman was my coworker. He knew what was going on.
You never told anyone because you made this whole slave thing up?
What?
You never told anyone because you made this whole slave thing up.
No, I felt like a slave and I was treated like one.
Thank you. No further questions, Your Honor.
Thank you. Redirect.
Briefly, Your Honor. Ms. Stark, why didn't you tell Frankie Lyman or Officer West you were being treated like a slave until March 10th?
I needed to keep my job to support my family, but after a while, my conditions became so unbearable, I couldn't take it anymore.
Thank you. Your Honor, nothing further. May this witness please be excused?
Yes, thank you. You may step down.
Your Honor, may I announce the case?
Yes, please.
The prosecution has used 4 minutes and 48 seconds and has 9 minutes and 12 seconds remaining for direct. The defense has used 2 minutes and 20 seconds and has 7 minutes and 40 seconds remaining for direct examinations. Thank you.
Thank you.
Please raise your right hand. Do you solemnly affirm that the testimony you're about to give will truthfully and faithfully conform to the rules and facts of the mock trial competition?
I do.
Please be seated, state your name, spell your last.
Julian Blake, B-L-A-K-E.
Thank you. You may examine.
Good afternoon, Miss Blake.
Good afternoon.
What is your occupation?
I'm a restaurant consultant as well as a restaurant owner and a chef.
What are your qualifications to be a restaurant consultant?
I'm a culinary school graduate and I've owned several small restaurants and diners.
Do you know the defendant, Cameron Aubrey?
Yes, Cameron and I have known each other since high school, and up until recently, I was hired as a consultant for his restaurant, The Taste of Tantera.
How did you begin your work with the restaurant?
Cameron and I started out by finding a decent property, and I immediately focused on the remodel because its condition just wouldn't do.
During this remodel, did you notice anything about the building that concerned you?
I did. I noticed that there was an automatically locking door located at the bottom of the stairwell. I told Cameron it was a major fire hazard and that he needed to have it removed.
How did the defendant respond to your warning?
He refused, and he told me the lock would be useful in case he ever needed to lock something away.
As consultant, did you ever assist with the hiring of any employees?
That's an important part of my job as a restaurant consultant, but Cameron refused my help.
Nonetheless, did the defendant describe to you what kind of employee he was looking for?
He did. He told me he was looking for the right type of employee. He said he used to work at a garment factory where they hired immigrant workers for very cheap. Cameron also told me that the boss there, and these are his exact words, got a lot out of them for very little cost.
To your knowledge, did the defendant ever hire a chef?
He did. He hired an immigrant, just like he had talked about. This poor girl named Lynn Stark.
Did you ever witness any interactions between the defendant and Miss Stark?
Yes, I was in the restaurant at least 3 days a week, so I would witness their interactions then.
How did the defendant typically treat Miss Stark?
When the restaurant opened, Cameron was so harsh towards Lynn. He made her work.
Sustained.
May I respond, Your Honor?
Go ahead.
Ms. Blake has already testified that she is a restaurant consultant, and specifically was a restaurant consultant at the Taste of Tantera, and that she was in the restaurant at least 3 times a week.
I don't think she's testified enough to lay a foundation that would make the answer to your question non-speculative, so you may proceed to ask some further questions to try to establish the foundation.
Yes, Your Honor.
Thank you.
How often were you at the Taste of Tantera?
At least 3 days a week.
And when you were there, did you see any interactions between the chef and the defendant?
I did. I noticed that Cameron seemed to yell at Lynn a lot.
Is that the only thing you noticed about how the defendant treated Miss Stark?
She threatened to have her deported if she didn't work faster, and she made her work an insane amount of hours.
Were you at all concerned with Miss Stark's working conditions?
I told Cameron that I was concerned that Lynn Stark's working conditions were outside the normal hours, salaries, and benefits of full-time chefs in small restaurants. Cameron's treatment of Lynn was dramatically out of line with industry standards, and I also told her that she might even be breaking labor laws.
How did the defendant respond when you warned him of this?
He told me that the staff was his proprietary interest and none of my business. He yelled at me and told me I had overstepped my boundaries. At that point, I ended our agreement and I quit.
Thank you. Your Honor, nothing further at this time.
Cross-examination, Ms. Baldwin.
May I proceed?
You may.
You didn't think Cameron Aubrey had sufficient funds to open up the restaurant, correct?
I didn't think he would have the necessary money to open the restaurant as well as pay for the necessary staff.
Yet you took a percentage of these profits.
I did, but I also had reduced fees.
Objection, non-responsive. Motion to strike.
Overruled. Motion to strike is denied.
And when Cameron told you about hiring foreign workers, you weren't concerned.
Objection, Your Honor, hearsay.
Overruled.
Can you repeat your question, please?
When Cameron told you about hiring foreign workers, you didn't think there was a problem.
I was concerned, but I didn't think much of it at the time.
In fact, you thought things were going great at first.
At first, before the restaurant had opened, yes.
And you claim you were concerned about the self-locking door to Lynn's apartment.
I was. The deadbolt on the door posed a major fire hazard.
But you didn't do anything when all Cameron Aubrey did was put up a sign.
I couldn't force him to have it removed.
And you claim you were concerned about Lynn Stark's pay, correct?
I was.
And Cameron said he couldn't afford to pay anymore.
I'm unaware of that.
You didn't offer to give up any of your pay to Lynn Stark.
I didn't think it was necessary.
No further questions, Your Honor.
Thank you. Redirect examination.
Really briefly, Your Honor. When you quit working at the Taste of Tantera, did you lose any of your financial benefits?
Yes, when I quit working at the Taste of Tantera, the fees that I was being paid as a consultant, as well as the profit-sharing agreement that Cameron and I had worked out, ended immediately.
Thank you. Your Honor, nothing further.
Thank you.
May this witness please be excused?
Yes, you may step down.
Thank you.
And your next witness.
The people call Officer Hayden West.
Thank you.
For the record, Your Honor, my name is Ingrid Adams, and I'll be conducting the cross-examination of this witness.
Thank you.
At this time, may the defense request for the times.
Yes.
Thank you.
One moment. The defense has used 3 minutes and 31 seconds and has 6 minutes and 29 seconds remaining for cross-examination. And for the people, you have used 8 minutes and 5 seconds and have, excuse me, give me 1 moment, please. 5 minutes and 55 seconds remaining.
Thank you.
Please raise your right hand. Do you solemnly affirm that the testimony you're about to give will truthfully and faithfully conform to the rules and facts of the mock trial competition?
I do.
Please be seated, state your name, spell your last.
Hayden West, W-E-S-T.
Thank you. You may examine.
Thank you. What is your occupation?
I'm a police officer with the Sanibel Police Department, as I have been for the past 7 years.
Are you familiar with a restaurant called Taste of Tantera?
Yes, ma'am. I'm a recurring customer there.
Did you get to know any of the employees at this restaurant?
Yes, I have spoken to the cook, Lynn Stark, and the owner, Cameron Aubrey.
Do you see Cameron Aubrey in the courtroom today?
Yes, he is seated on my right at the end of counsel table wearing a blue tie.
Your Honor, indicating the defendant?
The identification is noted for the record.
Were you at the restaurant on March 7, 2016?
I was.
And did you notice any interaction between the defendant and Lynn Stark on this date?
I saw the defendant yelling at Miss Stark, as I have seen many times before.
What did you do after seeing this?
I stepped outside to take a personal phone call when the defendant approached me. We had a short discussion, and then I discovered that there was a bench warrant out for Cameron Aubrey's arrest.
Once you discovered this...
Objection, Your Honor. More prejudicial than probative as to the bench warrant.
The objection's overruled. Thank you.
Once you discovered this, what did you do?
I arrested the defendant and placed him in the back of my patrol car.
Objection, Your Honor. More prejudicial than probative as for the rest.
The objection is overruled.
May it be heard?
Yes.
Your Honor, by mentioning that Cameron Aubrey was arrested on a false warrant, it leads the jury to believe that he may be involved in activity that he was not involved in, as the arrest was based on an improper warrant.
Do you wish to respond?
Yes, Your Honor. The fact that Cameron Aubrey came in contact with Officer West before the subsequent arrest was made on the human trafficking charges are extremely probative to today's case. As an offer of proof, I expect this witness to testify to a conversation that occurred between Officer West and Cameron Aubrey.
But why are the objection really is to the circumstances under which that conversation that you just referred to took place. And so the point I think that the defense is raising is that the fact that the defendant was arrested on a warrant that turned out to be invalid or not for this person, there's no reason for the trier of fact to hear that. Do you wish to respond?
Yes, Your Honor. I would be happy to move on with the court's permission.
All right, the objection sustained.
Your Honor, may the conversation about the arrest be stricken from the record. Thank you.
Or it is stricken, thank you.
After you made a U-turn with Cameron Aubrey in your car, did you say anything to the defendant?
I told him I thought he was abusive to his cook, Lynn Stark.
And how did the defendant respond?
He told me, "I don't know who you think you are, but you need to understand something. Everything under that roof is mine."
Did you ever interact with Lynn Stark after that incident?
Yes, on March 10th, Lynn Stark brought me my food with a note slipped under it saying, "Please help me, I'm treated like a slave."
Your Honor, may this witness please approach the diagrams?
Yes, you may step down.
Directing your attention to Exhibit B, do you recognize this?
Yes, this is a photograph of the note that Lynn Stark had slipped me.
What did you do after receiving this note?
I obtained a search warrant for the Taste of Tantera and performed the search myself.
Directing your attention to Exhibit A, do you recognize this?
Yes, this is a floor plan of the Taste of Tantera restaurant and Lynn Stark's apartment.
Is this a fair and accurate depiction as of March 10th, 2016?
Yes, it is.
Did you seize any evidence during your search?
I found Lynn Stark's work visa and passport in the room labeled office, here.
Where is Lynn Stark's apartment represented on the diagram?
It is the second floor of the building, which is represented by the lower section of this diagram.
What did you see in that apartment?
Not much. It was dark and dirty and had hardly any furniture. There was also an automatically locking door here.
Did you ever find a key to that door?
In the apartment, no. The only key I found to that door was on the defendant's key ring.
Thank you. Your Honor, nothing further. May this witness please resume her seat?
Yes, you may be seated, thank you.
Thank you.
Cross-examination.
Yes, Your Honor. May I inquire?
You may.
You were trained on the factors of human trafficking.
I was. I had a day-long training on human
Objection, Your
trafficking.
Honor, non-responsive. Move to strike everything after I was.
Oh, the motion is denied. The objection's overruled.
And one of the factors is limited contact with the outside world.
Yes, that is one of the many factors that I learned about victims of human trafficking.
And yet you went to the Taste of Tantera often, correct?
I was an occasional customer there.
And while you were a customer, you would speak to Lynn Stark.
I would. We would occasionally chat over the lunch counter while she prepared the food.
In fact, you were acquainted with Lynn Stark.
I would say so, yes.
Yet prior to March 10th, you never suspected human trafficking.
Prior to March 10th, no.
You claim that Cameron Aubrey yelled at Lynn Stark, correct?
He did, quite often.
And after seeing those occasions, you never questioned Lynn Stark if she was a victim of human trafficking.
No, I arrested Cameron Aubrey on the basis of everything
Objection,
that I
Your
had
Honor,
seen.
non-responsive. Move to strike everything after no.
The objection's overruled.
Okay. Your Honor, more prejudicial to probative as to the arrest.
Can't make string objections. You have to state all the bases at the beginning.
Yes, Your Honor.
So the objection's overruled.
I'll move on. And you claim that Cameron Aubrey said that everything under that roof is mine, correct?
He absolutely did.
But you didn't arrest him on the basis of human trafficking at that moment, correct?
I did not. Again, counsel, I arrested him on March 10th after everything that I had seen and all of the information that I was presented with.
And on March 9th, Julian Blake came to talk to you, correct?
She did, yes.
And upon hearing a complaint from Julian Blake, you didn't rush to check up on Lynn Stark, correct?
No, that was that evening, and the restaurant was closed at the time. I went to go see Lynn Stark the next day on March 10th at around 12:30 p.m.
It wasn't until the next day that you went to go see Lynn Stark.
Objection, Your Honor, asked and answered.
Sustained.
When you went to the Taste of Tantera, you ordered lunch the next day, correct?
I did, yes.
And then while waiting for lunch, you still didn't talk to Lynn Stark.
I did not.
In fact, it wasn't until Lynn Stark brought you the note that you went to get a search warrant, correct?
I did, because then at that point, everything came together and I knew that I needed to open an investigation.
And with that search warrant, the only thing that you found of importance in Mr. Aubrey's office was the passport and visa.
Yes, they were concealed on top of a folder on top of a desk.
And on that folder on top of the desk, it was not locked away.
No, it was not. They were concealed inside of a folder on top of a desk.
Nothing further, Your Honor.
Thank you. Redirect.
Briefly, Your Honor, why did you arrest Cameron Aubrey on March 10th?
It was the accumulation of everything that I had seen. From the interactions that I saw between Lynn Stark and the defendant, the conversation I had with Julian Blake, the note that Lynn Stark provided me with, the search that I performed, and the alarming comment made to me by the defendant while in the back of my police car, that led me to arrest him on March 10th for human trafficking and false imprisonment.
Thank you. Your Honor, nothing further. May this witness please be excused?
Yes, thank you. You may step down. You're
Thank you.
excused. And your next witness?
The people called Dana Greyjoy.
Thank you.
For the record, Your Honor, my name is Ingrid Adams, and I'll be conducting the cross-examination of this witness.
Thank you.
Your Honor, may I announce the times?
You may.
The prosecution has used 10 minutes and 55 seconds and has 3 minutes and 5 seconds remaining for direct examinations.
Thank you.
The defense has used 5 minutes and 26 seconds and has 4 minutes and 34 seconds remaining for cross-examinations. Thank you.
Thank you.
Please raise your right hand. Do you solemnly affirm that the testimony you're about to give will truthfully and faithfully conform to the rules and facts of the mock trial competition? I do. Please be seated, state your name, spell your last.
Dana Greyjoy, Greyjoy.
Thank you. You may inquire.
Good afternoon, Miss Greyjoy.
Good afternoon.
What do you do for a living?
I'm an expert in human trafficking, and I dedicate my time to working with victims of the crime.
What experience do you have in the field of human trafficking?
In addition to earning my master's degree in social work, over the past 20 years, I've served on anti-trafficking nonprofit boards, taught seminars, as well as testified in around 30 human trafficking cases.
Has your work been primarily for the prosecution in these cases?
Not at all. My work has been quite evenly split between the prosecution and the defense. I consult on cases regardless of which side is requesting my expertise.
Could you please explain to the court what human trafficking is?
Of course. Human trafficking is a modern-day form of slavery or indentured servitude.
How did you become involved with today's case?
I was asked to determine if Miss Stark exhibited any of the signs of a typical victim of human trafficking.
What exactly did you do?
I reviewed the case and then examined Miss Stark for any characteristics associated with a victim of human trafficking.
What are those characteristics?
These types of crimes tend to involve vulnerable victims who are typically manipulated using force, duress, and/or deception.
Well, let's start with force. What did you notice about force in today's case?
Miss Stark was forced to work 90-hour work weeks, making only around $2.29 an hour. And while this is slightly higher than what most victims are paid, it is still completely out of line with state laws. In addition, Miss Stark was prohibited from taking any breaks whatsoever or leaving the premises.
What did you notice about duress?
Mr. Aubrey had taken Miss Stark's government documents, her visa and her passport, which meant Miss Stark could not look for work anywhere else. Additionally, Miss Stark and independent witness Julian Blake both seeing Mr. Aubrey threaten Miss Stark with deportation if she was not working fast enough.
Finally, what did you notice about deception?
As in most cases of human trafficking, Miss Stark was lured with false promises. For example, that the defendant would help Miss Stark bring her family over to the United States. There is no evidence that the defendant ever took a single step towards this goal.
After reviewing all the facts, what final conclusion have you come to?
Miss Stark's long working hours, little pay, poor living conditions, and the concealment of her government documents all lead me to conclude that she is indeed a victim of human trafficking.
Thank you. Your Honor, nothing further.
Cross-examination.
Yes, Your Honor.
Ms. Adams, go ahead.
On your direct, you testified that Lynn Stark was a victim of human trafficking.
Yes, that's correct.
However, in your witness statement, you only say that she shares factors consistent with those of a human trafficking victim.
Yes, she does show characteristics consistent with those.
So let's talk about the factors of human trafficking. One factor is youth, correct?
Yes, that's true.
Lynn Stark was 25.
Yes, I would consider that young.
And another factor is limited education.
Yes, that's correct.
However, Lynn Stark had some college education, correct?
Yes, some, but she had to drop out in order to support her family, which is another characteristic of a victim of human trafficking.
But she did have education, correct?
She had some education, yes.
Another factor is limited contact with the outside world, correct?
Yes, that's correct.
And yet Lynn Stark had a friendship with Frankie Lyman.
Yes, Miss Lyman was Miss Stark's only friend.
Yet Lynn Stark had regular communication with Officer West.
Yes, she did.
In addition, Lynn Stark was able to leave the premises every single month to send money to her family.
Yes, but she would always be accompanied by a coworker.
But she was able to leave the premises, correct?
Yes.
In addition, you claim that human trafficking victims are paid little to nothing.
Yes, that's correct.
However, Lynn Stark received a salary.
Yes, she did receive a salary.
And with that salary, she was able to send money to her family every single month.
Yes, but this salary, when broken down, is completely below the minimum wage.
Objection, Your Honor, non-responsive.
Your Honor, may I be heard?
Yes.
Per stipulation 7, this witness is an expert, and she's explaining her answer to the best of her ability.
You should respond.
Your Honor, I asked a yes or no question, and the witness had answered with a yes, and that answers the question that Lynn Stark received a salary that she could send to her family every month.
All right, the objection's overruled.
In addition, you say that human trafficking victims have poor living conditions.
Yes, they do.
However, Lynn Stark had her own apartment.
Yes, but I would characterize it as being dark and isolated.
But it had its own bathroom.
Yes, with no door.
It had its own bed.
Yes, but it was a cot.
It was completely livable for Lynn Stark to live in.
Not comfortable for long-term living, no.
But she could live in it comfortably.
I suppose she could live in it, yes.
You based your conclusions on information that you received from Lynn Stark, correct?
Yes, I did.
And you never consulted Cameron Aubrey.
Of course not, counsel. I would hate to have violated your client's Fifth Amendment rights.
So you never considered that Lynn Stark worked at least the same amount of hours as Cameron Aubrey?
I suppose they did have some shared work, but...
Is that a yes?
Yes.
In addition, you didn't consider that Lynn Stark's stress may be due to the lack of experience as a chef, correct?
I suppose, but this lack of experience may have also led her to be exploited by Mr. Aubrey, excuse me.
In addition, you never considered that Lynn Stark had unrestricted access to the outside world.
I'm sorry, counsel, could you repeat your question?
You never considered that Lynn Stark had unrestricted access to the outside world.
While she could physically leave, without her government documents, realistically, she couldn't find other work.
But to clarify, she could have left the apartment any time that she wanted to.
Physically, yes, I suppose she could.
Thank you. Nothing further, Your Honor.
All right, redirect.
Yes, Your Honor, but first I'd ask for a time check.
Go ahead.
You have 31 seconds remaining.
Thank you. May I proceed?
You may.
Did you consider Ms. Stark's living conditions to be adequate?
No, her living conditions were completely terrible.
And what final conclusion have you come to, Ms. Greyjoy?
Ms. Stark shares several characteristics associated with those of a human trafficking victim.
And how confident are you in that conclusion?
I am extremely confident.
Thank you. Your Honor, nothing further. May this witness please be excused?
Yes, thank you. You may step down.
Thank you.
The people would like to enter Exhibits A and B into evidence.
Any objection?
No objection, Your Honor.
Thank you. They're ordered admitted.
At this time, the people rest.
Thank you. All right, the defense may call its first
At
witness.
this time, the defense calls Cameron Aubrey.
Thank you. Please come forward.
Please raise your right hand. Do you solemnly affirm that the testimony you're about to give will truthfully and faithfully conform to the rules and facts of the mock trial competition?
I do.
Please be seated, state your name, spell your last.
Cameron Aubrey, A-W-B-R-E-Y.
May I proceed?
Thank you. You may inquire.
Good afternoon, Mr. Aubrey.
Good afternoon.
Are you familiar with the restaurant Taste of Tantera?
Well, it was my dream to open the Taste of Tantera, but that quickly turned into a nightmare because of the stressed out chef and crazy consultant that I hired.
So why specifically Tanteran food?
Well, in my youth, I spent a lot of time volunteering in Tantera, and I really wanted to just spread the culture to America.
Objection, Your Honor. Relevance and inadmissible character evidence. May I explain?
Now, the objection sustained.
Move to strike, Your Honor.
It is ordered stricken.
Thank you.
Go ahead.
You mentioned your consultant. What was this consultant like?
Well, Julian Blake was constantly running up charges. I had to take out loans just to pay for her services. And on top of that, she was criticizing every single decision that I made for my restaurant.
Objection, Your Honor. Unfair extrapolation as to Julian Blake running up costs on the restaurant.
Where is that in the record, Ms. Evans?
Directing the court's attention to page 37, lines 29 through 31. I also used the loans to pay for Julian's services. If the restaurant made as much money as Julian thought it would, then it would take about 5 years to make all my money back and pay off the loans.
May I respond, Your Honor?
How is it a fair extrapolation from those facts that he was running up the cost, or she was running up the costs?
Julian Blake was the one that suggested that Cameron Aubrey take out the loans, which he wouldn't have done without Julian Blake's advice.
The objection sustained.
Move to strike, Your Honor.
Motion to strike is granted.
Thank you.
You mentioned your dream was turned into a nightmare because of your chef. How was this individual hired?
My cousin Devin Tyler suggested to put an ad out in Little Tantera.
Objection, Your Honor. Hearsay.
Overruled.
Who did you end up hiring to work at the Taste of Tantera?
Lynn Stark, because she spoke English well and had great tasting and authentic Tanteran cuisine.
You mentioned she was stressed. What kind of specific problems did Lynn Stark have around the restaurant?
Well, at first, everything was going great. We were getting along, we were making the menu together. We were going to make this restaurant successful. But then the moment the restaurant opened, she was too stressed to work in the kitchen.
Objection, Your Honor. Speculation.
Overruled.
What were Lynn Stark's pay arrangements like?
I was going to pay for the room, board, and utilities. It's hard to open a restaurant, and I told Lynn that I wasn't sure how much I was going to be able to pay her.
Where did Lynn live while working at the Taste of Tantera?
I offered to pay for the apartment above the restaurant.
Did you live on site at the restaurant as well?
I had the mortgage on my house to pay on top of everything else, so no.
Now, Mr. Aubrey, do you know an Officer West?
She occasionally came to the restaurant. She was a little rude.
Did you ever tell her that everything under that roof belonged to you?
Well, I meant that restaurant is my business. It's not Wes. And I was offended that Wes even arrested me and was making these accusations.
Now, back to Lynn Stark's apartment. Did Lynn Stark's apartment have any sort of self-locking door?
Well, there was a self-locking door, but I didn't think it was ever going to be an issue because we both had keys and it was to remained open at all times.
Did Lynn ever get locked in this apartment?
Well, there was an argument and I did close the door, but I never thought that Lynn was ever in any danger because she always had the key to the apartment.
Did you ever offer Lynn any constructive criticism around the workplace?
I was always trying to give Lynn constructive feedback, but she never took any of my advice, even though I was trying to motivate her to help her so we could get through the restaurant together.
Now, Mr. Aubrey, did you have Lynn's passport and visa?
I was trying to sponsor Lynn, and I was going to hire a lawyer because I didn't exactly know what to do to sponsor Lynn.
Did she ever ask for her passport and visa back?
I would have gladly given it to her if she ever asked for it, but she never did.
Did you ever threaten Lynn with deportation?
I was afraid Lynn was going to quit on me.
Did you ever deprive Lynn of her freedom?
Lynn was never forbade at all from ever leaving the restaurant.
Did you intend to keep Lynn for slave labor?
No.
Thank you. No further questions, Your Honor.
Thank you. Cross-examination.
Yes, Your Honor. May I proceed? seat.
You may.
Good afternoon, Mr. Aubrey.
Good afternoon.
You had no idea how to start a restaurant, did you?
That's why I hired Devin Tyler. I got my
Objection, Your Honor, non-responsive.
Sustained.
Move to strike?
I don't know that there was anything to be stricken.
Yes, Your Honor. Mr. Aubrey, you had no idea how to start a restaurant, yes or no?
That's why my cousin suggested to hire Julian Blake.
Objection, Your Honor, non-responsive. I asked this witness a yes or no question.
The objection sustained.
Move to strike the answer, Your Honor.
It is ordered stricken.
Mr. Aubrey, you had no idea how to start a restaurant, yes or no?
Objection argumentative.
Overruled.
No, I did not.
But you did have an idea about the type of employee you wanted, true?
I wanted someone who knew the American dream and would work very hard with a lot of motivation to achieve that, just like me.
Well, you worked in a garment factory before opening your restaurant, didn't you?
I was a security guard there, yes.
And at that factory, you observed that the workers worked very hard, true?
They were going to achieve their own American dream, yes.
So, Mr. Aubrey, they worked very hard, right?
With a lot of motivation, I saw, yes.
Julian Blake seemed concerned about your ability to finance a restaurant, didn't she?
She did, but I knew that I was going to be able to make my restaurant work with my funds.
Objection, Your Honor, non-responsive as to the last portion of the answer.
Overruled.
And you addressed Ms. Blake's concerns by responding to those same factory workers, didn't you?
I told her that I wanted someone who would work hard with a lot of motivation.
Well, in fact, Mr. Aubrey, your exact words were people who were, quote, working hard with a lot of motivation to reach the American dream, right?
No, I never said that.
Mr. Aubrey, do you recall writing a witness statement?
I do.
And were you truthful and honest in that statement?
I was.
And isn't it true that on page 37, lines 20 through 21, I told Julian in my previous job I saw people working hard with a lot of motivation to reach the American dream? You wrote that, didn't you?
I did.
Now, when you interviewed Lynn Stark, you knew that she was here on a temporary work visa, correct?
That came up in the interview, yes.
And you were aware that she wanted to bring her family over to the United States, correct?
I offered to bring her family to the United States, yes.
And she was exactly the kind of employee that you wanted, wasn't she?
I don't understand what you're getting at, counsel.
Well, Mr. Aubrey, she was someone that you believed had that motivation to reach the American dream, correct?
Just like me, yes, counsel. I wanted someone who was going to be compatible with me.
Now, it's your testimony that Lynn Stark often complained about the number of hours she worked, true?
I believe so, yes.
And yet you claim that you have no idea how many hours Lynn Stark was working, right?
Well, we never kept any timesheets, so I don't know at all, no.
Well, let's break it down. Your restaurant was open 6 days a week, wasn't it?
I believe so.
And during all those 6 days, you were open for lunch and dinner, weren't you?
I was working all those hours, yes.
Mr. Aubrey, directing you back to my question, your restaurant was open for lunch and dinner 6 days a week, correct?
Yes, it was.
Being the head chef, Lynn Stark had to be there all 6 days, didn't she?
Well, I needed authentic and delicious cuisine, so yes.
In fact, she even was coming in on her days off to work additional hours, correct?
I don't recall that happening.
And Mr. Aubrey, Lynn Stark did come in to work on Sundays, right?
That might have happened a couple of times, yes.
So she was basically working almost all day, at least 6 days a week, correct?
Well, I was upfront that opening a restaurant was going to be very rough the first couple of months.
Objection, Your Honor, non-responsive.
Sustained.
Move to strike.
The answer is ordered stricken.
Mr. Aubrey, Lynn Stark was working almost all day, at least 6 days a week, wasn't she?
I was working just as much hours as she was, yes.
Objection, Your Honor, non-responsive.
The objection sustained. The answer is ordered stricken.
Your Honor, I'd ask the court to admonish the witness to please answer my questions.
Listen carefully to the question and respond to the question that's actually being asked.
Yes, Your Honor.
Mr. Aubrey, Lynn Stark was working at least 6 days a week, almost all day long. Yes or no?
Yes.
Yet you got into an argument with Lynn Stark over her request for time off, didn't you?
She only told me that she wanted to take a vacation, so yes.
And that made you angry, didn't it, Mr. Aubrey?
It did.
And because you were so angry, you slammed the door to Lynn Stark's apartment behind her, didn't you?
I never thought that she was in any danger, but yes.
And you knew that this was an automatically locking door, right?
Yes.
And other than that one door, there was no other way out of Lynn Stark's apartment, was there?
No.
Thank you. Your Honor, nothing further.
Thank you.
Redirect, Your Honor.
Redirect.
Mr. Aubrey, why didn't you hire more employees to work at the Taste of Tantera?
Objection, Your Honor, outside the scope of cross.
Overruled.
Well, because of the loans that I had to take out to pay for Julian Blake's services, I couldn't hire anybody else.
How many hours did you work in comparison to Lynn Stark?
I was working just as much, if not more, than Lynn.
Thank you. No further questions, Your Honor.
Thank you. You may step down.
Thank you, Your Honor.
The defense may call its next witness.
Your Honor, at this time, the defense calls Devin Tyler.
Thank you.
May I announce the times, Your Honor?
Yes, please.
The defense has used 3 minutes and 24 seconds and has 10 minutes and 36 seconds remaining. The prosecution has used 4 minutes and 10 seconds and has 5 minutes and 50 seconds remaining for cross-examinations.
Thank you.
Please raise your right hand. Do you solemnly affirm that the testimony you're about to give will truthfully and faithfully conform to the rules and facts of the mock trial competition?
I do.
Please be seated. State your name, spelling your last.
Devin Tyler, Tyler.
Your Honor, may I inquire?
You may.
Good afternoon, Ms. Tyler.
Good afternoon.
What is your current occupation?
I am a hotel manager for my very own hotel, Le Petit Chateau, and I also volunteer at Santa Bella Community Church.
Do you know Cameron Aubrey?
Cameron is my dear cousin. We went on multiple mission trips to Tantera together, which is what gave him the passion to open a Tanteran restaurant.
Did you help Mr. Aubrey open that Tanteran restaurant?
Well, I helped Cameron with 2 very important decisions. The first was to hire a restaurant developer, and the second was to place an ad in the newspaper that circulated Little Tantera to find an authentic chef.
Do you know Julian Blake?
Julian is our old friend from high school who Cameron hired as restaurant developer.
Did you see Julian Blake and Cameron Aubrey interact?
Well, Julian was very aggressive and very opinionated. I thought she was trying to increase fees.
Do you know who Lynn Stark is?
Lynn is the immigrant from Tantera Cameron hired as chef.
Did you see Lynn Stark and Cameron Aubrey interact?
Well, Lynn and Cameron had a really great relationship in the beginning. They would always laugh and talk about their dreams of the future, and they really bonded over the fact that they both had a passion for Tanteran culture.
Objection, Your Honor, speculation.
Overruled.
Did the relationship change once the restaurant opened?
Well, once the restaurant opened, Lynn started working much more slowly, and I was worried she wouldn't be able to handle the stress of working in the kitchen. And every time Cameron tried to give her constructive feedback, she would argue with him. Very unprofessional.
Objection, Your Honor, speculation as to every time that the defendant witnessed this and it occurred.
The objection's overruled.
Based on your experience with Cameron Aubrey, do you think that he would ever be abusive to an employee?
Cameron is the most kind-hearted, loving person I know, and he would never intentionally hurt someone, especially someone in need.
Thank you, Ms. Tyler.
My pleasure.
Nothing further, Your Honor.
Cross-examination?
Yes, Your Honor.
Go ahead.
The defendant is your cousin, correct?
Cameron and I are cousins.
And on direct examination, you testified that you two used to travel to Tantera together, right?
We went on a few mission trips in high school, yes.
And you also said you believe the defendant is a good-hearted person and is loving, true?
Cameron is very kind-hearted. We grew up together.
That's a yes, that she is good-hearted and loving, correct?
Cameron is very good-hearted.
In your opinion, would a good-hearted person lock an employee in a room and say, it's going to be a long time before you go anywhere?
Well, Cameron never intentionally locked anyone away.
Ms. Tyler was not asking about Cameron. I was giving you a hypothetical. Would you like me to ask the question again?
Sure.
In your opinion, would a good-hearted person lock an employee in a room and say, it's going to be a long time before you go anywhere?
Well, a good-hearted person wouldn't do something like that.
You offered the defendant some advice about the cost of opening a restaurant, true?
I offered some very important advice, yes.
And that very important advice was that the restaurant would be extremely costly to open, true?
Well, it is always hard to open a business.
Is that a yes? You told the defendant it would be extremely costly?
I told Cameron of the difficulties that it would be to open a
Objection,
restaurant.
Your Honor, non-responsive. I asked if this witness recalled her sharing with the defendant.
objection
It was
sustained.
Motion to strike?
Granted.
You told the defendant it would be extremely costly to open a restaurant, yes or no?
I told Cameron it was, yes.
And shortly after you told this to the defendant, he hired Lynn Stark, an immigrant, to be his chef, correct?
Cameron was very passionate about helping Lynn.
Is that a yes? He hired an immigrant shortly after you shared this with him.
Cameron did hire Lynn. He
Shortly
wanted to
after-
give her a chance.
Objection, Your Honor, speculation as to the latter portion of that answer.
The objection's overruled.
Just 2 months into the restaurant being open, the defendant confided in you that things were not good, correct?
Cameron did tell me about the financial situation of the restaurant.
But somehow, the defendant was able to keep the restaurant open for another 2 months, true?
Well, Cameron is
Is
very
that a
good at what he
yes?
does,
That
yes.
she was, thank you.
Objection, Your Honor. Relevance as to the previous question made.
The objection's overruled.
And during those 2 months, Lynn Stark was the only chef working, yes or no?
Well, yes, Cameron gave
Thank
Lynn a
you.
chance.
You've answered my question. No further questions.
Thank you. Redirect.
May I inquire?
You may.
Why do you think that Lynn Stark was the only person hired in the restaurant as a head chef?
Well, Cameron wanted to give Lynn a chance. He really wanted to provide for her and help her bring her family home. And Lynn was the only chef there, but Cameron wanted to give her a chance.
Thank you.
Objection, Your Honor, speculation as to all of the wants that the defendant had. May I explain?
No, the objection's overruled.
Thank you. Nothing further, Your Honor.
All right, thank you. You may step down. And your next witness.
At this time, the defense calls Frankie Lyman.
Thank you.
May I announce the times?
You may.
The defense has used 5 minutes and 30 seconds and has 8 minutes and 30 seconds remaining for direct examinations. The prosecution has used 6 minutes and 14 seconds and has 3 minutes and 46 seconds remaining for cross-examinations.
Thank you.
For the record, Your Honor, my name is Carly Baldwin, and I'll be giving the direct examination of this witness.
Thank you.
Please raise your right hand. Do you solemnly affirm that the testimony you're about to give will truthfully and faithfully conform to the rules and facts of the mock trial competition?
I do.
Please be seated. State your name, spelling your last.
Frankie Lyman, capital L-Y-M-A-N.
May I proceed?
You may inquire.
Good afternoon, Ms. Lyman.
Good afternoon.
Were you employed October of 2015?
I was working at the Taste of Tantera along with Lynn Stark.
Who hired you to work at the Taste of Tantera?
Mr. Cameron Aubrey hired me.
Do you see Mr. Aubrey in this courtroom today?
Mr. Aubrey sitting at the end of the table with the blue tie on.
May the record reflect that this witness has identified Cameron Aubrey?
The identification is noted for the record.
Thank you. Now, you mentioned working with Lynn Stark. Do you know what her duties were around the restaurant?
She did the chopping, the slicing, the dicing, the seasoning, the usual chef stuff, you know?
Did Lynn ever go out and buy groceries to prepare this food?
This one time Lynn went out and she was gone for a long time and she came back with a nasty attitude.
Objection, Your Honor, unfair extrapolation.
Want to point me to, I believe in the, no, I'm going to overrule the objection because I believe in the fact, in the statement from this witness and in the statement, I believe from, in Cameron Aubrey's statement, there are facts regarding Ms. Stark's attitude when she returned from that shopping trip. The objection is overruled.
Did Lynn Stark ever leave for any other reasons?
Me and Lynn left a few times together to wire money back to your family. I want to say $300 to $350 each time.
Did you spend much time with Lynn other than to wire money to her family?
I spent a lot of time with Lynn. I got to know about her family and how she wanted to bring them to America.
Did you ever get a chance to see Lynn Stark's apartment?
She took me up there a few times. It wasn't the best thing, but it seemed comfortable, you know?
How did Lynn Stark seem to handle the work situation?
Lynn honestly seemed to be a mess.
Now, how did Cameron Aubrey handle this?
Cameron Aubrey gave her feedback, but she just ignored it and she continued to struggle.
Did Lynn Stark ever confide to you about her legal status?
Lynn told me she was going to get fired and deported and that she would do anything to stay in America. She honestly seemed so desperate.
Objection, Your Honor, hearsay.
Your Honor, may I be heard?
You may.
This goes to Lynn Stark's state of mind and motive to accuse Cameron Aubrey of human trafficking, which is the defense's position.
You wish to respond?
Your Honor, this statement does not fall under the hearsay exception state of mind. Hearsay exception C, state of mind, refers to the then existing emotional state of the declarant. However, this does not go to Lynn Stark's any kind of emotional state that she had.
Now, the objection is overruled.
Was Lynn ever treated unfairly around the Taste of Tantera?
Lynn was treated like family. She could eat all the meals she wanted and she had a free apartment.
Thank you. No further questions, Your Honor.
Thank you. Cross-examination, Ms. Arndt.
Yes, Your Honor. Ms. Lyman, Lynn Stark was a co-worker of yours at Taste of Tantera, correct?
Yes, she was.
Shortly after the restaurant opened, you witnessed her leave to go buy vegetables, correct?
Yes, I did.
And when she didn't return at the exact time she said she would, you saw the defendant begin to appear nervous, didn't you?
Objection. This question calls for speculation.
Overruled.
Can you repeat the question? I'm sorry.
When Lynn Stark didn't return exactly when she said she would, the defendant appeared nervous, yes or no?
When she returned later, a lot later than she said she would, the defendant was upset because we couldn't continue on without.
Objection,
Ms.
Your
Stark.
Honor. Speculation and non-responsiveness to the latter portion of the answer.
The objection's overruled.
After that incident, you never saw Lynn Stark leave to go run errands again, did you?
She was allowed to leave, just not get vegetables.
Ms. Lyman, Lynn Stark never left the restaurant after that incident by herself, yes or no?
We left together.
But she never left by herself, Ms. Lyman, is that correct?
Objection. Relevance.
May I respond, Your Honor?
No, the objection's overruled.
I don't think so.
Now, on March 9th, 2016, you saw Cameron Aubrey coming out of Lynn Stark's apartment, correct?
He went up there to fix a leaky faucet.
And yes, exactly. He mentioned that he was fixing the leaky faucet, didn't he?
Yes, he did.
But you didn't see any tools in his hands, did you, Ms. Lyman?
I didn't see anything in his hands.
So you didn't see any tools?
No tools.
Thank you. Your Honor, nothing further.
Thank you. Redirect.
Not at this time, Your Honor.
Thank you. You may sit down.
Thank you.
Excused. And your last witness.
Yes, Your Honor. The defense calls Addison Frey to the stand.
Thank you.
And for the record, my name is Ingrid Adams, and I'm conducting the direct examination of this witness.
Thank you, Ms. Adams.
May I announce the times?
You may.
The defense has used 7 minutes and 8 seconds and has 6 minutes and 52 seconds remaining for direct examinations. The people have used 7 minutes and 23 seconds and have 2 minutes and 37 seconds remaining for cross-examinations.
Thank you. Please raise your right hand. Do you solemnly affirm the testimony you're about to give will truthfully and faithfully conform to the rules and facts of the mock trial competition? I do. Please be seated. State your name, spelling your last.
Addison Frey, F-R-E-Y.
Thank you.
May
You
I
may
inquire?
inquire.
Thank you. Good afternoon, Ms. Frey.
Good afternoon.
What is your occupation?
I have my master's in social work, and I have my own private practice as a therapist and a consultant, where I'm often contacted by the Santa Paula Police Department to interview victims of violent crimes, such as human trafficking.
Have you ever been qualified as an expert in human trafficking?
I have testified in about 10 trials as a human trafficking expert.
How are you involved in today's case?
I was asked by the defense to reevaluate Ms. Greyjoy's findings.
How did you go about your reevaluation?
I looked at 4 different aspects. I interviewed Lynn Stark, I interviewed Cameron Aubrey, I also inspected Lynn's apartment, and I looked at Ms. Greyjoy's findings.
Do you agree with Ms. Greyjoy's findings that Lynn Stark was a victim of human trafficking?
Absolutely not. The only thing I agree with Ms. Greyjoy is her definition of human trafficking, a form of modern-day slavery.
Why don't you agree with Ms. Greyjoy's findings?
I'd like to begin by stating it's clear to me that the relationship between Cameron Aubrey and Ms. Stark was a legitimate employee-employer relationship. Lynn Stark was paid every month, and Mr. Aubrey worked alongside her.
Next, Lynn's feelings of depression, anxiety, and helplessness are all attributed to her lack of experience. Ms. Stark simply wasn't qualified to work in this type of environment. And Lynn's lack of familiarity with American culture has led her to perceive her relationship with Mr. Aubrey as something it absolutely is not, something completely abnormal.
Typically, how are human trafficking victims controlled by their traffickers?
Victims of human trafficking are often subjected to inhumane working and living conditions. They're paid pennies an hour, if anything, and they're typically financially indebted to their trafficker.
How does this apply to Lynn Stark's case?
Lynn Stark is absolutely not financially indebted to Cameron Aubrey. Mr. Aubrey paid Lynn every month. She lived in an apartment she did not have to pay for. She ate food she didn't have to pay for. And in addition to this, she had a surplus amount of money to send back home to Tantera every month.
What did you find when you inspected Lynn Stark's living quarters?
It was Spartan but habitable. I've never seen a human trafficking case in which the victim had such adequate living quarters with unrestricted access to the outside world.
What do you mean by unrestricted access to the outside world?
All exterior doors of the restaurant could be opened from the inside without the use of a key. Lynn Stark had a key to her apartment that she could use to leave her apartment and exit through the restaurant doors at any time. This absolutely is unrestricted access to the outside world.
Thank you, Ms. Frey. Nothing further, Your Honor.
Thank you. Cross-examination.
Yes, Your Honor. May I inquire?
You may.
When you spoke to Ms. Stark, it was clear to you that she was suffering from chronic physical pain, right?
Due to the extent of her work.
And it was clear to you that she was suffering from anxiety and depression, right?
Being unprepared to work in such a working environment, yes, she was.
And these ailments were clear to you even though Ms. Stark had been out of Taste of Tantera for over a month, isn't that right?
These type of feelings can linger, counsel.
Is that a yes to my question?
Yes, it is.
On direct examination, you said you found it unusual that Ms. Stark had such unrestricted access to the outside world, right?
Typically, counsel, victims of human trafficking don't get their own keys to their own apartment.
Ms. Stark was working a minimum of 96 hours per week, right?
I can't answer that question. There's no evidence of clocking in or out, so.
So you are an expert in human trafficking, and you came to a conclusion in this case without knowing how many hours Lynn Stark was working?
This is based off self-reporting, and I can attest to that.
The door to Ms. Stark's apartment automatically locked from both sides when it shut, didn't it?
And it was said through a sign that Lynn Stark could read.
Objection, Your Honor, non-responsive.
Overruled.
Yes or no, the door to Ms. Stark's apartment automatically locked from both sides when it shut?
It did, and she knew that, yes.
On March 9th, Ms. Stark was locked in her apartment by that same door, wasn't she?
She was known to have a key, counsel.
Was she locked in her apartment on March 9th by that door?
Yes, she was.
And the windows in Ms. Stark's apartment were barred in, weren't they?
It was an industrial situation, setting.
Is that a yes to my question?
Yes, as shown in the exhibit A.
Ms. Stark wasn't supposed to go out by herself, was she?
No one was stopping her from going out with a friend, counsel. This was to her own discretion.
So she was allowed to go outside if she was accompanied by a friend, right?
Absolutely not. She could leave anytime she wanted to at her own discretion, as I've already said, counsel.
30 You're only familiar with one instance where she did go out by herself, right?
Which instance would this be, counsel?
She went out to buy vegetables, true?
That is true.
And when she returned just 5 minutes late, she was reprimanded by Cameron Aubrey, wasn't she?
Mr. Aubrey is just running his business as efficiently as he can.
Objection, Your Honor, non-responsive.
Sustained.
Move to strike.
Stricken.
Lynn Stark was reprimanded by Cameron Aubrey, yes or no?
For being late, yes.
Thank you. Your Honor, nothing further.
Thank you.
Redirect, Your Honor. Thank you.
You may
inquire?
proceed.
Thank you. Why can you not determine the amount of hours that Lynn Stark worked?
There isn't any evidence of a time clock on the premises, so I can't attest to one person's uncorroborated reports.
And could Lynn Stark leave the apartment any time that she wanted to?
Of course, absolutely. No one was stopping her, and she had her own key.
Thank you. Nothing further, Your Honor. May this witness be excused?
Yes, thank you. You may step down.
At this time, the defense rests.
Thank you. You may proceed.
Thank you, Your Honor. Lynn Stark came to America from Tantera, hoping to realize a modest dream, find a job, work hard, earn an income to support herself and her family. In short, like so many immigrants, she came to this country in search of the American dream. But what the defendant delivered was a nightmare. Now, Cameron Aubrey promised Lynn Stark that she would be paid, housed, and maybe someday reunited with her family. But there was one problem. Lynn Stark did not know who the defendant really is. The defendant is charged in count 1 with human trafficking, depriving another of their personal liberty with the intent to obtain forced services. First, defendant Cameron Aubrey intended to obtain forced labor from Lynn Stark. Your Honor, today you heard from Julian Blake, who worked with the defendant during those first few months. Ms. Blake testified that the defendant admitted that he planned on hiring immigrant workers because he could, quote, get a lot out of them for very little cost. So he specifically looked for a cook in Little Tantera. Your Honor, remember what expert Dana Greyjoy told you today about victims of human trafficking. They're typically young, desperate immigrants, isolated from their families and unfamiliar with American culture. This perfectly describes Lynn Stark. And the defendant confirmed these characteristics when he asked Lynn Stark about her family and finances, even going so far as to ask, would anyone in Little Tantera miss you if you were gone? And when Lynn Stark answered no, the defendant knew that he had found his perfect victim. So he made Lynn Stark live on the premises as part of her employment. And Julian Blake told you her concerns about that apartment, that the only door had a double-cylinder deadbolt on it, requiring a key to unlock it from either side. But the defendant chose to ignore these statements and didn't remove the lock because, as he said, it would be very useful if he ever needed to, quote, lock something away. It is clear that when the defendant forced Lynn Stark into that apartment, he had already formulated a plan to get a lot out of her for very little cost. Now, the second element of the offense, that the defendant deprived Lynn Stark of her personal liberty. Your Honor, where do we start? Well, to begin with, the defendant took Lynn Stark's visa and passport away, claiming that he needed them to sponsor the visa and bring Ms. Stark's family over to the United States. But half a year later, the defendant had done nothing to keep those promises. And when Lynn Stark asked for her documents back, the defendant refused. Furthermore, the defendant conveniently claims to have no idea how many hours Lynn Stark was working. But if we break it down, we can see that Lynn Stark was working 7 days a week, nearly all day, every day. So why would the defendant claim to not know how many hours the most important employee in his restaurant was working? Because, Your Honor, the defendant contrived this lie to hide the fact that he was exploiting his immigrant worker. And this was summed up perfectly when he told Officer West that, quote, everything under that roof is mine. Under duress and coercion, Lynn Stark's personal liberty was being intentionally violated by Cameron Aubrey. But there's more. When the defendant's growing anger and frustration finally came to a head, he locked Lynn Stark in her apartment and didn't let her out. To prove that the defendant is guilty of count 2, false imprisonment, we must establish that the defendant intentionally and unlawfully confined the victim somewhere against her will. When the defendant slammed that door behind Lynn Stark, He knew exactly what he was doing. He knew Lynn Stark wouldn't be able to get out because he had removed the key from her apartment earlier that day. Frankie Lyman, the defense's own witness, testified to seeing Cameron Aubrey coming out of the apartment. The defendant had no credible reason for being there, and when Officer West searched the apartment for the key, she couldn't find it. So the defendant slammed that door, knowing Lynn Stark would be trapped inside. And from the outside, knowing that his victim wouldn't be able to get out, the defendant taunted, "It's going to be a while before you go anywhere." Cameron Aubrey was the only person who could let Lynn Stark out of that barred, jail-like apartment in the middle of nowhere. And when he finally did,
30
he
seconds.
laughed and sneered, "Missing your key?" Your Honor, all Lynn Stark wanted was to live the American dream and to someday be reunited with her family. But instead, she was exploited and imprisoned in a nightmare. Hold the defendant accountable for his actions. Find him guilty. Thank you.
Thank you. For the defense.
May I proceed?
You may.
Your Honor, this is the case of the American dream. The American dream gone bad. It is not about a naive immigrant whose pursuit of this dream led her to be a victim of human trafficking. Rather, it's the story of Cameron Aubrey, whose dream to open a Tantaran restaurant was ruined by Lynn Stark, an immigrant who thought she was about to be fired and deported, made false claims of human trafficking because she would do anything to stay in the United States. The prosecution's case against Cameron Aubrey is based on Lynn Stark's claims of poor treatment, on the statements of Julian Blake, a disgruntled employee who was asked to resign because of conflicts in the workplace, and Officer West, who disliked Cameron Aubrey. Officer West, who was trained to detect human trafficking, who was a regular patron at Cameron Aubrey's restaurant, yet never saw signs of human trafficking until Julian Blake and Lynn Stark made their claims. But the real victim here is Cameron Aubrey, who had a dream to open a Tantaran restaurant. He had a deep connection to Tantara, having volunteered there during his teenage years. And he was finally able to make that dream come true when he received an inheritance. In his previous job, Cameron had seen people working hard with a lot of motivation to reach the American dream. And this is what he planned to do in his own business. Work hard, find like-minded employees who wanted their American dream. Cameron never suggested some sinister plot to hire foreign workers for little cost. Cameron thought he had found such a compatible employee in Lynn Stark, and Lynn's cooking was delicious and authentic. Cameron was upfront about the fact he didn't know how much he could afford to pay Lynn, but offered Lynn an apartment above the restaurant and free food. Cameron gave Lynn Stark money for toiletries in the beginning, paid for Lynn to call home weekly, and even offered to help bring Lynn's family to America. Cameron took Lynn's passport and visa only to help Lynn remain in the United States. But Lynn Stark's inexperience in working in a busy kitchen soon became apparent. Devin Tyler and Frankie Lyman, a friend and co-worker of Lynn, said that Lynn worked very slowly. Lynn struggled to keep up. When Cameron offered constructive criticism, Lynn Stark became angry and would argue with Cameron. Lynn Stark saw the writing on the wall. Lynn Stark confided to Frankie Lyman that she was afraid of being fired and deported. Lynn Stark told Frankie Lyman she would do anything to stay in the United States. And so Lynn Stark slipped a note to Officer West saying, "Help, I'm treated like a slave." A way to remain in the United States. Lynn Stark spent a lot of time with Frankie Lyman when work was slow. Frankie even helped send money to Lynn's family back in Tantara. Never once did Lynn Stark confide to Frankie Lyman for help, because confiding to Frankie Lyman for help would not have allowed Lynn to remain in the United States. Dana Greyjoy, the prosecution's expert, said that Lynn exhibited many factors consistent with those of a typical human trafficking victim, but does admit that Lynn Stark was paid more than the typical human trafficking victim. that most human trafficking victims are young, whereas Lynn is 25 and college educated in accounting. And most importantly, Dana Greyjoy fails to acknowledge Lynn Stark's access to outside support in Officer West, Julian Blake, Devin Tyler, and Frankie Lyman. Fails to acknowledge Lynn Stark's incapability to keep up in her job. Now, Addison Frey, the defense's expert, explained that Cameron Aubrey and Lynn Stark had a legitimate employment relationship, and that Lynn Stark suffered from stress of being in a job she was not prepared to handle, and that cultural differences caused her to misinterpret Cameron's behaviors as a demanding boss. And most importantly, Addison Frey, who saw Lynn Stark's apartment, said she had never seen a human trafficking case where a victim had such unrestricted access to the outside world with such adequate living quarters. Cameron Aubrey didn't restrain Lynn's liberty. The one time Lynn got locked in Lynn's apartment was because Lynn lost track of her key. When there are two reasonable interpretations of the evidence, one pointing to the defendant's innocence and one pointing to the defendant's guilt, you must adopt that which points to innocence and reject that which points to guilt. In the instant case, there is a reasonable interpretation that Lynn Stark is not a victim of human trafficking, that Lynn Stark was free to leave anytime, especially as Cameron Aubrey did not live on site of the restaurant, that Lynn Stark needed to find a way to avoid being fired. So she made up these claims.
1 minute.
President Harry S. Truman often liked to say, if you can't handle the heat, get out of the kitchen. And Lynn Stark couldn't handle the heat of working in a busy kitchen. But rather than to get out of the restaurant, Lynn Stark accused Cameron Aubrey of human trafficking. The defense asks you to find Cameron Aubrey not guilty of all charges. Thank you.
Thank you. Ms. Howell, go ahead. You may proceed.
Thank you. Your Honor, the defense is grasping at straws, trying to paint Cameron Aubrey as a victim. Let's review. It was not Lynn Stark who told a consultant that she wanted to hire immigrant employees to get a lot out of them for little cost. That was Cameron Aubrey. It was not Lynn Stark who took a passport and visa from an immigrant worker and withheld them when the worker asked for them back. That too was Cameron Aubrey. It was not Lynn Stark who imprisoned an employee in an apartment for an entire night, removing the key so she couldn't get out. That was Cameron Aubrey. Your Honor, the people have met their burden of proof. We have proven that Cameron Aubrey intended to exploit Lynn Stark and imprison her in her apartment. Find Cameron Aubrey guilty. Thank you.
Thank you. All right, both sides want a moment to confer with your...
Your Honor, the defense requests that they give their rebuttal now.
Oh, I apologize. Go ahead.
May I proceed?
Yes, you may.
English professor Azir Nafisi famously stated, "The negative side of the American dream comes when the people pursue it at any cost, which in turn destroys the vision and the dream." Now, as opposing counsel stated, Lynn Stark had an American dream, and she pursued it at any cost, which in turn destroyed my client, Cameron Aubrey's dream. Now, Cameron Aubrey may not have been boss of the year, but he was not a human trafficker. Lynn Stark applied for the job at Tantera. Lynn Stark could have quit her job, but no. Instead, Lynn Stark continued to pursue her American dream at any cost and blamed my client, Cameron Aubrey, of human trafficking. The defense asks you to find Cameron Aubrey not guilty. Thank you.
Thank you. All right. And now, do you wish time to consult with your attorney coaches?
None from the people, Your Honor.
Thank you.
Nothing from the defense, Your Honor.
All right, thank you. Well, one side here is going to, and I don't know which side, but one set of witnesses and lawyers is going to go on after today to the state competition. And since I don't know which side that is, I wanted to make a few comments to both sides. a very few. Let me begin by saying that in the courtroom where I preside in a federal court, we don't have bailiffs. If we did, Ms. Franklin, I hope you would be mine. You have tremendous presence, and you're both courteous and treat everyone fairly, and truly, you've got a voice that most of us would give anything for. I don't know what your eventual career plans are, but I hope to see you sometime in my courtroom displaying that remarkable presence that you have. Now, someone else who's kind of often forgotten, but is critical, would be the clerk. Now, I do have a clerk, and she's great, and she's promised not to retire until I do. But if things change, I would be happy to see you in that very important position, which I sometimes refer to as the brains behind the operation. And I know you are under a lot of pressure in what you do in this competition. But again, maybe sometimes you don't always get the recognition you deserve. You did a wonderful job. So thank you. Now, as to the attorneys, both sides were just really terrific. And although I've judged this competition for many, many years, as you could probably tell, sometimes I still, the things that are done a little differently in this competition, there's not that many, I get a little confused about. So one comment I want to make to both sides, I'm not sure that it really applies in mock trial, but I thought both sides' opening statements were very good, but they were too argumentative. And I have been known to interrupt attorneys during an opening, which is a really critical part of the presentation, to say, refrain from argument. So I don't know, you may have a little more leeway in the mock trial competition, and maybe it's acceptable, but you might want to consider that a little bit. And then I noticed that both sides did this, not every time, but a couple of times at least on both sides. And that is when I call on you to, I think it was always redirect, you said, just briefly, Your Honor. Well, my advice, and I hear that all the time in everyday trial, so it was very authentic, is the good news. My advice is never to say that, just be brief. Because it doesn't make it briefer if you say briefly, Your Honor. But people say that. I don't think in my courtroom I ever call on an attorney to do redirect where they don't say briefly, Your Honor. By about day 4 of the trial, the jury just starts laughing because they feel like it probably won't be brief if they said briefly. Those are, I thought both sides, I was really impressed by a couple of things both sides did. Your knowledge of the facts of the case was wonderful. It was thorough and deep, and I thought both sides did a good job of using the facts fairly. There were only 1 or 2 objections about unfair extrapolation. I thought it was a close enough call that I had no problem with the objection, even if I didn't sustain it. But both sides were really on your toes on knowing all the facts. Let's see, one or 2 of the cross-examinations, I thought the witnesses were particularly good. Gabrielle Oyama did a really excellent job under a very good cross-examination. I think everybody did. And you've all obviously had good experience and have listened to the coaches about how to control a difficult witnesses, because I don't think any of these witnesses were particularly easy to control in cross-examination. You all did a really good job with that. Luckily, I don't have to score you. I mean, luckily from my point of view, because it would be a very difficult decision. I'm truly impressed by your poise and also by the way you reacted to my rulings, appropriately asking sometimes to be heard, but very politely moving on if the ruling was against you. And that shows real grace, and I really appreciated that. Now my verdict. I guess You will have to stand up, Mr. Aubrey, to hear the verdict. Which is a verdict of guilty. Guilty beyond a reasonable doubt on both counts. Got to still stand, you know. But don't worry, there is no sentencing in these proceedings. So I don't have to display my leniency. And I'll finish up by acknowledging what a full courtroom this is, and that means that you've had so much support over all of these months of incredibly hard work from your teachers and the attorney coaches, your family members. So let's give a hand to all of them. It is really inspiring to me to see this kind of support and then to see the results in the very fine performances by all of the witnesses and, of course, by all of your counsels. So congratulations to you, both sides, for your incredibly talented and diligent performance here. I wish all of you the very best.
Thank you, Your Honor.